Good afternoon, everyone, et bienvenue à notre comité permanent sur la justice et droit.
Welcome to the Standing Committee on Justice and Human Rights.
To once again welcome Mr. McEachern to our committee as a temporary member.
No, I'm just a fill-in.
And also Mr. Oliphant, who's joining us for the first time.
Hooray, hooray. Not as a witness.
That's right. This is the first time he's been here not as a witness. The roles are reversed. And it's great to be back on our study on counseling and other mental health support for jurors. We have a fascinating panel today. Two of the different panelists are joining us by video conference. I would like to welcome from the Government of Saskatchewan, Ms. Glenys Bihun, who is the Executive Director and Inspector, Court Offices, Court Services, Ministry of Justice. Welcome. You can hear me well?
Well, thank you.
Excellent. And Mr. Warren Miller, who is the Sheriff and Local Registrar of the Queensbench Court Services, Ministry of Justice. They're joining us by video from Regina, and they will be speaking first. Then we intend to have from Australia, Ms. Jane Goodman-Delahunty, who is a professor, Faculty of Business, Justice and Behavioral Sciences at the Charles Sturt University. She has not yet joined us, but she will shortly. The intention is to have both of those on video conference go first in case somehow we lose the video conference. We don't want to miss your testimony. We hope that will not happen. So for the folks from the Government of Saskatchewan, you have approximately 8 minutes to deliver your opening statement. The other groups will then deliver their statements, and then we'll go to questions. Okay?
Thank you.
Perfect. And joining us here today, we have Ms. Cathy Kamkar, who is a clinical psychologist for the Center for Addiction and Mental Health. Welcome, Ms. Kamkar. From the Criminal Lawyers Association, a frequent witness for us, we have Ms. Breeze Davies, who's the Vice President. Welcome back, Ms. Davies.
Good afternoon, thanks.
And Ms. Vanessa McDonald, the Associate Professor of Faculty of Law, Common Law Section, University of Ottawa. Welcome, Ms. McDonald.
Thank you.
Then we have de la Commission de la Santé Mentale du Canada.
From the Mental Health Commission of Canada, Michel Rodrigue, Vice President, Organizational Performance and Public Affairs. Welcome, Mr. Rodrigue.
Mr. Michael Petras, who is the Director of Mental Health First Aid Canada and Opening Minds. Welcome, Mr. Petras.
Thank you very much.
So we're looking forward to some fascinating testimony from today, and I will turn it over to the Government of Saskatchewan.
Thank you. Good afternoon, Mr. Chairperson and honorable committee members. Thank you for this opportunity to address you regarding the newly implemented Saskatchewan Juror Assistance and Support Program. By way of an introduction, my name is Warren Miller, and I've been employed with the Ministry of Justice in Saskatchewan in the Court Services branch for 28 years. The majority of that time I've spent working in a frontline court manager role as the Sheriff and Local Registrar. I'm currently the Sheriff and Local Registrar for the Judicial Centre of Moose Jaw. In addition, I recently spent approximately 4 years in an acting role as the Director of Court Operations for Southern Saskatchewan. It was during that period that I became more focused on the area of overall jury management in Saskatchewan, including support for jurors. I've been involved with numerous jury trials involving serious offenses where both graphic images and evidence were tendered as evidence during the course of my career. With me today is Ms. Glenys Bihun, Executive Director of the Court Services Branch and the Minister's Designated Inspector of Court Offices for Saskatchewan. Jurors are called upon to consider what can be horrific and gruesome evidence as part of the important role they play in the administration of justice in our province. The experience has the potential to cause distress to jurors who are typically unaccustomed to such things. There is more social awareness of mental health issues now than there ever has been. There's a recognition that jury service could have a detrimental effect or negative impact on an individual, and it is appropriate that the state provides assistance and support to those citizens who have served as jurors. Saskatchewan has between 20 and 30 jury trials take place each year, significantly less than either Alberta or Ontario, but the need to support those who do serve as jurors is a priority. Emotional support for jurors was identified as a key area for improvement in the fall of 2016. We became aware of the work being done in Alberta and Ontario, so I connected with colleagues in both provinces to seek out details as to their efforts and experiences, including the recommendations made by Madam Justice Hughes related to counseling for jurors. We are very appreciative of the information shared with us, and we've relied upon their experiences in designing a similar program for Saskatchewan. Based on the information we received from Alberta regarding utilization, we estimated that our annual cost for the program would be less than the threshold for a formal request for proposal, or RFP. Therefore, in accordance with our procurement requirements, we reached out to several established service providers in our province. This resulted in the receipt of 3 service quotations. These quotations were reviewed for how best they met 4 criteria: ease of use for participants, accessibility for participants, confidentiality, and professionalism in service delivery. The service provider needed to be able to facilitate access to support via a 24-hour hotline, available 7 days a week. The ability to provide face-to-face support in multiple locations was also important, as Saskatchewan has 9 judicial centres, plus 2 satellite court locations, and the coroner's branch conducts inquests in additional locations around the province. Confidentiality for the juror, their fellow jurors, and the deliberation process was emphasized. All counselors were expected to have a minimum of a master's degree in social work or psychology with a minimum of 5 years of practical experience. Following this evaluation, a 2-year service contract was established with Morneau Chappelle. The Juror Assistance and Support Program is administered by the Inspector of Court Offices. The Saskatchewan Juror Assistance and Support Program was launched and publicly announced by our Minister on November 30th, 2017. The announcement was carried by several major media outlets, and information regarding the new program was placed on the Government of Saskatchewan website with links from the Saskatchewan Courts website. Hard copies of pamphlets and information is also being made available in all our judicial centres to ensure the public is aware of the existence of this new program. Effective December 1st, 2017, the Ministry's Juror Assistance and Support Program policy requires the Sheriff's offices provide all jurors with the program brochure at the conclusion of their service or during the proceeding at the direction of the court. Jurors would typically be instructed by the court regarding the sanctity of the deliberation process and be cautioned not to share information in this respect. Saskatchewan's Juror Assistance and Support Program is accessible to all those who participate as a juror in a criminal trial, a civil trial, or a coroner's inquest in Saskatchewan. The program is accessible to those who experience personal difficulty within 2 months following the conclusion of a case, or at the court's discretion during the case. To access the program, jurors call the established toll-free number to reach professional intake staff who are available 24/7 to connect jurors with counselors in their area. Currently, there are 96 counselors who are available in 24 Saskatchewan communities. Counseling will take place in person wherever possible, and alternative methods of communication will be supported for jurors in remote areas. The program will provide jurors access to 4 treatment sessions with a healthcare professional to help them overcome the difficulties related to their jury service. Up to an additional 4 sessions may be approved at the recommendation of the service provider. Approval may also be granted for the spouse, life partner, or other significant family member of the juror to be permitted to participate in the sessions where appropriate. All program-supported sessions are to be concluded within 24 months of the completion of the jury duty. For those people who served as a juror prior to December 1st, 2017, they are eligible to request services by contacting the service provider in writing with the following information: confirmation that they served as a juror within the 2-year period, December 1st, 2015 to November 30th, 2017, and evidence that they started experiencing personal difficulty within 2 months following the conclusion of the case they served on. At the end of the program treatment sessions, the individual would be referred to his or her health care practitioner under the Saskatchewan Health Plan if further treatment is required. As with all programs of this nature, maintaining a participant's anonymity is essential. All Saskatchewan jurors are provided with a unique number when they attend for jury selection. And this juror number, it will be the identifier used rather than the participant's name. We have planned reviews of this new program at 6 months and 1 year. And similar to what is being done in Alberta, Ontario, mechanisms are already in place to obtain feedback from those jurors who access the program so that their experience can assist with our review process. As of last week, there have not yet been any requests for service in Saskatchewan. We are grateful to and respect all those who act as jurors. They play a very important role in society. We are pleased to have implemented this program to support them. Thank you again for this opportunity to provide you with information on the program, and we would now be happy to answer any questions you may have regarding our new program. Thank you.
Thank you very much, Mr. Miller. On behalf of the government of Saskatchewan, it was much appreciated. And it looks like we have now been joined by Professor Goodman-Delahunty. Professor Goodman-Delahunty, do you hear me?
Yes, I do.
Okay, perfect. So I'm Anthony Housefather. I'm the chairman of the committee. And what we're doing, because we had yourself and another witness by video conference, we're doing the two of your testimony first so that we don't lose you. So basically, you have, at this point, 8 to 10 minutes, hopefully trending toward 8. Then we have some more witnesses in the room, and then we're going to go to questions, if that's okay. And thank you so much for joining us from so far away. It's very appreciative, especially given the hour difference. So the floor is yours.
Thank you very much, and good afternoon, committee members and other attendees. It is a great pleasure to join you from here in Sydney, Australia today. By way of background, I'll just introduce myself. I'm trained in law and experimental psychology, and I have done jury research and evaluation of jury programs for approximately 30 years, working first of all in the United States and then more recently here in Australia and New Zealand. As part of that work, I did a number of studies that have looked at different aspects of juror stress. And so I wanted to commence my remarks by just summarizing, in response to your request, some of the various ways that stresses can arise for jurors in the course of their jury duty from the outset and on through the post-deliberation and post-verdict process, as we've just heard about in Saskatchewan, where services have been provided on a follow-up basis. And so I think it's important as a background to understand that jurors are moving into a very unfamiliar environment to them. This can be very intimidating, and that alone can be somewhat stressful, particularly because they're required not to discuss their experiences and particularly the content of the evidence and their thoughts about it with others. And so they're in a way cut off from their normal support systems, which is why the need for the courts to provide some additional support systems is important. Their daily lives are very disrupted by adjusting to the court schedule, often requiring them to travel, and there's often uncertainty of the duration of the trial and the attendance of their jury duty, which alone and can be very difficult and impose some stress in terms of managing their day-to-day schedules. The unfamiliarity of the decision task and the fact-finding role that is imposed on them requires quite a lot of learning and guidance from the courts. And of course, their decision-making is often one which has very serious consequences for the defendant if a verdict to convict is imposed. And jurors feel this burden of participation in the justice system due to the seriousness of the consequences of their decision. Working with strangers itself can be quite stressful for jurors in adjusting to the dynamics of a consensus-making decision model that is required in the process of fact-finding and reaching a verdict, and particularly learning to get along with other jurors and figuring out what the process of the decision-making can be itself is tricky. And most of all, jurors suffer from a loss of control over their lives and the decision making in this experience, which can be quite unpredictable for them. And so if we think about their experience once they come into the courtroom environment, oftentimes, first of all, they're a little confused as to how they should go about responding to just the issues of selection, which vary considerably from one community to another. In Australia, for example, we learned that the fact that jurors in certain states have to parade in front of the defendant during the process of peremptory challenges is particularly excruciating and intimidating because they walk across and then might be challenged, and it's regarded as, by some, quite an insulting process. And so efforts have been made to try to ameliorate that sort of confrontation with jurors even before they may have opened their mouths. Answering questions about reasons they might seek excusal if they're entitled to it in public can be very embarrassing, depending on what the reasons are that they might want to seek excusal. And so procedures that provide them the opportunity to do that in a more confidential environment or ahead of time are very much appreciated by jurors. So depending on the kinds of processes that exist for challenges as well as for individuals who have legitimate reasons not to serve on jury, need to be sensitively treated by the jury administrators as well. Other issues as you move on through the process are also important to consider. And I wanted to talk a little bit next just about the need for ongoing communication with jurors once they proceed through the selection process, because while they might have had some liaising officers right at the outset, at the jury pool room or at the jury administration office where they initially report, oftentimes once they're assigned to a case, they're off in a courthouse that might in fact be in another location or another building way away from the jury administration staff with whom they've initially become acquainted and comfortable. And so it's very important to make it clear to them who should be their liaising support. Is it someone on the court staff, or is there some other person or mechanism that they can use if they do need support during the trial once they're assigned to a particular case? The physical facilities in which jurors work are often a neglected source of concern and stress to juries. And for example, in some very traditional or older courthouses, oftentimes the conditions are less than optimal. We've had some difficulties that I can relate here in the Australian context, where some older buildings that were never purpose-built as jury rooms or deliberation rooms, but in fact were, converted from other uses that those buildings once had before, in fact, as department stores in one of the largest courthouses in Sydney. What has happened is that the deliberation rooms are quite cramped, often windowless, and do not afford jurors an opportunity for what we would call some breakout space during the discussion. In other words, there is only a conference table around which people sit in cramped quarters in which they have to spend long hours with very little relief. And what we've learned from a great deal of psychological research is that, in fact, just those physical creature kinds of comforts can make a great deal to relieve some of the pressure of the burden of the decision that people are grappling with. And so it's important to take the physical environment into account as well, and to provide people a break from the working quarters if they are cramped. Ideally, to have facilities for jurors designed so that they are comfortable, include some some additional seating aside from the conference table for smaller discussions by jurors during the duration of the trial. And if possible, to have openable windows, natural light, and particularly some sort of outlook or view that can offer visual relief is really more facilitative of productive discussions and less inclined to result in tension and conflict between jurors. Of course, during the trial, as we've heard from the former speaker as well, there is the potential that some of the evidence may be very confronting, and particularly if it is gruesome evidence, that can be particularly stressful. And so it's important to try to provide the jury with some sort of warning in advance that is forthcoming, to try to give them some options to manage that. And we have found it helpful also if that sort of material is not presented in very lengthy series, but rather in series of a shorter duration, not just before lunch or not just after lunch, and not very late in the day either. So that jurors have some time for relief and processing of that information, often perhaps requiring a break after some confronting information is presented, as well as the option to seek support and to seek counseling if they find it particularly disturbing. In terms of the decision-making process itself in deliberations, some of the innovations in jury research that seem to be most promising are what are sometimes called fact-based question trails, or sorts of decision trees that are decision-making aids that are given to jurors to help them to structure the discussion process once they get into the deliberation room and are actually able to start putting together the facts and working on the consensus of the group together. I think New Zealand has been the leader in this area of research. It's also a very popular trend growing in Australian courtrooms, because what it does is it helps to take some of the burden off of jurors in terms of understanding complex legal language, because a lot of the legal issues are in fact embedded in the question trails that then guide jurors just through the issues that they have to address factually. And the feedback that has come from experimental work testing these kinds of processes against traditional jury directions is that it's much appreciated that juries are more efficient and that their decision making is more streamlined than in other situations. So that seems to be a commendable issue to look at. Jurors also need some guidance on what to do in terms of understanding what is ordinary, healthy exchange of ideas and disagreement or dissent in a jury deliberation, and what is unhealthy, coercive, and sometimes even bullying, because they're not often given any guidance as to what to do if things become stressful in the deliberation room because of the confidentiality requirements that are attached to the deliberation process. There have been some cases where after a verdict has been rendered, courts have been surprised to find in an Australian courtroom, for example, a note left on a deliberation table afterwards by one juror who argued that he was actually physically coerced to reach a verdict of consensus with fellow jurors. And then the court was confronted with the issue of ought that confidentiality of deliberation, to be penetrated in order to try to resolve whether, in fact, there was something that went awry, and so that you don't find yourself in that situation. It's clearly important rather to give jurors some guidance on how to deal with disagreement and what to do so that they don't feel that they have no recourse at all if deliberations do need some guidance or some time out or some consultation to resolve conflicts.
Professor Goodman-Delahunty, just to let you know on time, you're sort of running a little bit long. Could I ask you to maybe summarize in a minute if you have anything left, and then we'll come back with questions?
Yes, absolutely. I think the last point that I want to emphasize is I think that it is valuable for jurors to receive some debriefing, whether it is conducted by the trial presiding judge or whether it is conducted by a professional, particularly in cases that have been of long duration or cases where there has been confronting or gruesome evidence. Aside from making available to jurors some counseling and support services, and we have found in Australia that at least around 20% of the jurors do take up that offer if they feel comfortable and trusting of the confidential counseling service. But in addition, some general debriefing that provides closure seems to be a very positive way to end the jury experience. And thank you.
Thank you very much. I really appreciate it. And next, we will move to the Center for Addiction and Mental Health. Ms. Kamkar.
Thank you very much. Dear members of the House of Commons Standing Committee on Justice and Human Rights, I would like to thank you for the opportunity to discuss mental health supports for our jurors. I'm Dr. Kathy Kamkar, clinical psychologist at the Center for Addiction and Mental Health, assistant professor within the Department of Psychiatry, University of Toronto. I'm also director of Badge of Life Canada, which is a peer-led national charitable organization for police, corrections, first responders across Canada who are dealing with psychological injuries suffered in the line of duty. I'm also serving on the Canadian Institute for Public Safety Research and Treatment, National Policing Research Committee. I'm also part of the Scientific Advisory Committee, Anxiety Disorders Association of British Columbia, as well as a founding and credentialed member of the Canadian Association of Cognitive Behavioral Therapies. Do our jurors need access to mental health support? The answer is yes. Mental illnesses play a major impact on our economy. The estimated annual healthcare costs are about 51 billion Canadian dollars, driven in part by the fact that mental health problems are associated with reduced productivity at work, increased absenteeism, sick leave, short-term and long-term disability. The costs associated with mental health disabilities are also higher than those of physical-related disabilities and 7 times more likely to reoccur. Focusing on the mental health promotion, prevention, and early intervention would benefit the public, the employers, workers, families, insurance companies, and our society. The focus would produce a positive return on investment, including reduced social, occupational, mental, and physical disability, reduced medical utilization, improved therapy outcomes and prognosis with a return to a healthier functioning, improved social and family relationships, and improved well-being and quality of life. Serving on a jury can lead to increased stress level, as well as significant psychological distress and emotional difficulties, including feeling anxious, depressed, helpless, and overwhelmed. The emotional experience can increase vulnerability to psychological disorders, including depression, anxiety disorders, substance use disorders, as well as trauma and stressor-related disorders. Within the Diagnostic and Statistical Manual of Mental Disorders, 5th edition, DSM-5, there is a greater recognition and understanding of vicarious trauma, which can occur after experiencing repeated or extreme exposure to aversive details of traumatic events. our jurors can be exposed to diverse, traumatic, and gruesome evidence during their service through detailed written materials, photographs, audio content, videos, graphic verbal descriptions. Jurors also tend to witness firsthand the emotional impact traumatic events can have on victims, families, and witnesses. The exposure to such evidence and sequelae tends to be repeated throughout the day and over a period of time. There are additional stressors that compound the risk for mental health problems among jurors, including feelings of isolation, limited social support, and fear of making a mistake. In addition, there are jury discussions, deliberations, verdict renderings that involve worry and anxiety about trial-related decisions, including determining the outcome of trials, such as the guilt or innocence of a defendant. The stressors are further exacerbated by social and time pressures inherent in providing jury service. In some cases, trial materials resembling a juror's own personal history can substantially increase vulnerability for mental health problems. Similarly, materials involving violence or crimes against people or crimes involving children also tend to increase vulnerability to mental health problems. We need to implement a care plan for jurors, and that care should begin early as part of pre-service preparations. Provide education about the potential impact of traumatic material during the jury service, common psychological symptoms one might experience, what constitute normal reactions, and what reactions should be taken as warning signs for engaging more help. Healthy coping resources should be provided prior to trial to help with anticipatory anxiety and its transition from normal life to jury service. The same resources should be available during the trial to minimize the negative consequences of service. During the trial, there should be a support system. For example, social and psychological support in place to help reduce sense of self-isolation, maintain jurors' mental health and well-being, provide adaptive and healthy coping with feelings of helplessness, anxiety, stress, or any emotional difficulties. Funding and access to evidence-based mental health interventions following court case should be available when needed. Mental health experts should be available for providing evidence-based mental health services. Consultation with a mental health professional, psychologists and/or psychiatrists should be strongly recommended for an accurate diagnosis and discussion of various treatment options. Contact information should be provided to help access additional mental health services if needed. Evidence-based cognitive behavioral therapy, CBT, is effective for numerous psychological disorders and is at least as effective as medication. Research suggests that CBT offers the most benefits when completed with a trained mental health professional. The gains that are observed with CBT are long-lasting and tend to be maintained longer than improvements achieved by medication alone. Upon meeting with the healthcare professional, it is also important to establish clear treatment plan and goals and to monitor progress toward those goals. Dear members of the House of Commons Standing Committee on Justice and Human Rights, I would like to thank you again for the opportunity to discuss mental health support for our jurors. Providing funding for evidence-based treatment and having a support system in place for our Canadians who are performing such important civic duty would be essential for all the reasons just mentioned and will contribute to the mental health promotion of Canadians and be a positive return on investment, and most importantly, the very human thing to do. Thank you.
Thank you very much. Much appreciated. We will now move to the Criminal Lawyers Association. Ms. Davies, the floor is yours.
Thank you. Thank you once again for inviting the Criminal Lawyers Association to present before you. And I want to start off by saying that our basic position is that we're delighted to see that the federal government is interested in this issue, and we broadly support efforts to provide counseling and mental health services to jurors after difficult cases. I'm the vice president of the Criminal Lawyers Association in Ontario, but I'm also practicing defense lawyer, and I've been involved in a number of cases that have the sort of evidence that you've heard about causing difficulties for jurors, and involved in one case where on an ad hoc basis supports were provided to jurors because of the nature of the evidence. Our submissions today are going to focus on two issues, and we're going to split them between Vanessa and I. Vanessa is going to deal with the importance of providing mental health supports as a means of ensuring representativeness of jurors, which is an important issue. And I'm going to talk about perhaps the opportunity you might have to think about this in maybe a slightly broader perspective than what you've got right now, and to suggest to you that you might want to think about extending supports to all participants in the justice system to the extent that they don't have access to them already. Our position is that will promote access to justice. It will ensure retention of lawyers in the profession, particularly women, racialized lawyers, and it will ensure that we start reducing the stigma in the legal profession around mental health issues. So you've heard evidence, lots of evidence about vicarious trauma and how exposure to evidence can cause vicarious trauma. And if you accept, which I hope you do, that the research is clear that exposure from a single case to difficult evidence can cause jurors to have significant psychiatric difficulties, you must also accept that prolonged exposure over time by lawyers on a repeated basis can also cause that exact sort of trauma. The impact on people's lives are serious, and so for that reason we support providing these supports for jurors, but we also suggest you might look at it a bit broader. On the specific issue of jurors, I think one of the things you're going to have to look at is Section 649 of the Criminal Code, which is a jury secrecy issue. You've already heard from Saskatchewan that there's a prohibition about speaking about deliberations. I'm sure you'll take a look at it. It only provides for discussion of deliberations in respect of investigations. It strikes me that investigations of jury tampering, it strikes me that may well limit the ability of jurors to actually seek and obtain the sort of support that they need to the extent that their psychiatric issues arise from or are exacerbated by the deliberation process. So that's one issue. Why are we suggesting that you should look at this more broadly? And it won't surprise you that I'm going to suggest that really what you need to do is extend this to lawyers, and in particular defense lawyers, and I'll explain why in a minute. So you'll know, or some of you might know, that in criminal cases, Crown and Defense Counsel work very hard often to limit the sort of evidence that gets put before a jury. So Crowns and defense actually get exposed to much more, and often much more graphic information than judges or jurors, because we take time to minimize the prejudice and minimize the impact. So the reality is that lawyers are exposed to a lot more of this sort of information. It's also the reality that most of the participants in the criminal justice system, if we think about judges, Crown attorneys, court officers, they are usually employed people by either the government or other institutions, and have access to benefits. Defense counsel, by contrast, are usually sole practitioners, self-employed, who wouldn't otherwise have access to the sorts of supports that you're talking about. If they need the supports, they're going to have to pay for them out of pocket. And the research has been done. The University of Toronto, a researcher named Renate Dinovitzer, has done research that shows 1 in 4 lawyers suffers from mental health issues. Lawyers who are self-employed or in private practice are more likely to suffer from mental health issues than government or public sector lawyers. So if you take that together, it strikes me that it's clear that defense lawyers are at particular risk of experiencing mental health issues and not having the supports available to deal with it as well. We're also interested in ensuring that people stay in the profession. We've done studies, I know some of you know about it, about the retention of women in the practice. We know that women are 5 times more likely to leave defense practice to go to the Crown's office, largely because of the benefits that are available there. So if we're interested in retaining diversity in the profession, it's one of the issues you may want to look at. So we are delighted that you're studying this issue. We think it's important, but if you want a healthy, properly functioning justice system, we think that you should also think about extending whatever benefits that you might extend to jurors to those other members of the justice system who don't otherwise have access to them. There are member assistance programs that are very narrow in some provinces through the law societies, but we would encourage you to expand it and open the net for the safety net that you're providing for everybody involved. And I'm going to turn it over to Vanessa to deal with the other issue.
So I'm going to sort of pick up on the diversity point that Brice raised. And so another way of thinking about sort of the broader context of the discussion we're having today is to think about the whole range of supports that are or are not available to jurors when they end up performing this important democratic function. And in addition to sort of pointing out that there is, or at least until recently, in most provinces, there's been a real lack of mental health supports, there's also a significant ongoing problem in a lot of provinces with just the very basic supports that we provide to jurors. And so what I'm talking about here are, for example, the daily stipends that are provided to jurors who are required to turn up and to perform their civic duty. So trials that last between 1 and 10 days, jurors are not paid anything to be there. Their employers must, by law, give them time off work, but there's no obligation to continue paying employees. So that already influences fairly significantly who's able to make themselves available. Once trials extend beyond 10 days, there are modest stipends that are available, and that amount goes up for very long trials. But the bottom line is that the lack of a meaningful income supplement for jurors who are called to serve in this way is a real disincentive. And more than that, it essentially renders jury service for entire groups of people impossible. And so what we've seen over time is we talk about the jury as being this great democratic institution, but for many people, they justifiably ask to be excused because they just they can't afford it. In addition to there not being meaningful income supplements, there's also, in most provinces, no support provided to offset the costs of childcare or elder care. So what we end up having is a pool of jurors who, we start out thinking about this group as being the peers of the accused, but at the end of the day, we have a group that's really much smaller. And so to the extent that this committee is considering the mental health supports that we provide to jurors, the CLA would also recommend that you think a little bit more broadly about the way that we support jurors in performing this function. And that's not only important because we want juries to be diverse and to represent the diversity of our society. We want all individuals to be able to serve. But this also has a very real impact on the accused, who has a constitutional right to a representative jury. And there was a major report that was released in 2013 in Ontario by former Justice Frank Iacobucci that identified some significant concerns from the standpoint of representativeness on Ontario juries. And he identified the issue of these income supplements, the lack of childcare, elder care supports as being significant factors in some of the representativeness problems that plague the province. And there the concern was, in particular, with the underrepresentation of Indigenous people. So there's lots of authority that establishes that this is a problem. And so to the extent that, as I said, this committee is thinking about how we support jurors and the relationship between that support and the fair trial rights of an accused person, in our view, it's really important to take that holistic approach. Thank you.
Thank you very much. On va passer maintenant à la Commission de la Santé du Canada. Monsieur Rodrigue.
Merci bien. Thank you, Mr. Chair, for inviting the Commission to provide our perspective on the jurors' mental health. Before I begin, I would like to congratulate this committee for focusing on the mental health risks of jury duty, a topic about which relatively little is known, but impacts individuals in a very real way. When the Mental Health Commission was created in 2007, one of the key priorities was to launch an anti-stigma campaign. Why? Because we recognize that mental health care would remain in the shadows if people were not willing to talk about it and to ask for help. On the heels of Bell Let's Talk Day, it is very encouraging to see the conversation about mental illness. But much remains to be done to move from conversation to action in delivering mental health services when and where people need it. So I think it's a broader issue, and now I'll focus specifically on the issue that jurors deal with. What is clear is that jury duty is in it itself stressful, as the witness from Australia quite competently outlined. We asked regular citizens without any special training to make life-altering decisions about people charged with serious offenses. This can be a heavy burden to bear. There can also be serious psychological harm caused by exposures to acts of depravity and tragic events that are explored during trials. We've learned about the vicarious trauma throughout these hearings. They can occur in anyone who has a traumatic experience, and not everyone is impacted in the same way. Since the post-duty experiences of jurors are not tracked, we don't know exactly how many of them experience vicarious trauma or operational stress injury. Monsieur le Président, de nombreux jurés ont besoin d'une aide professionnelle.
Mr. Chairman, many jurors do require professional help and should be in a position to receive it in order to overcome the psychological stress resulting from their jury experience. There are many effective measures that help with the recovery and improving the quality of life of persons using these measures. For example, access to counseling is important, and you would not be surprised to know that access to such services is quite inadequate. We recently looked into a number of possibilities to assist provinces and territories in ensuring better access to such services. However, as a number of other witnesses have noted, these jurors require people to whom they can turn in order to obtain support. The only way to ensure that mental health remains on our radar screen is to be able to talk about it. I strongly encourage this committee then to look at the effectiveness of prevention and resilience. By resilience, I mean the ability of an individual to adapt to stress, to overcome obstacles, and to cope with adversity. Resilience is at the heart of the work of the Mental Health Commission of Canada, just as the struggle against stigmatization and discrimination. In Canada, we have increasing evidence to demonstrate that programs encouraging self-awareness and resilience can make a significant difference. For example, the programs that we have been managing, Spirit at Work or Getting Ready Mentally, adapted from material used by the Department of National Defense, are of great use. The Liberal and Conservative members of this committee will recognize a good part of the content of these programs since they were used in the training sessions that we recently provided to your caucuses and that we will be providing soon for the NDP caucus. These programs help participants realize what the warning signs are of distress and to request help if necessary. We also have programs that are adapted to police services as well as first responders. It would be quite simple then to adopt these programs as of today.
Public programming tailored to the needs of jurors doesn't exist, or barely exist. Jurors have had to themselves often navigate the mental health system with its long and longer wait times and pay for services directly. If we ask citizens to provide a public service, such as jury duty, they should have access to tailored mental health care to deal with the impact of their public service. This in turn also requires informed decision and research. For all those reasons, the Mental Health Commission of Canada is highlighting 5 elements around which the committee could consider framing your recommendations. Firstly, you should consider offering pre-trial mental health awareness education to jurors, such as the working mind or the road to mental readiness, particularly in cases involving serious crimes. Second, where there is a chance that jurors will be exposed to traumatic images and testimony, courts should consider arranging for access to a mental health professional throughout the trial. Third, government should seriously consider strategies to ensure timely access to publicly funded diagnostic services and evidence-based treatments for jurors. We can command what's happening in Saskatchewan. It's a wonderful first start. Fourth, we can share the mental health professionals and others we should clarify and address Section 649 of the Criminal Code so that a juror can access professional help or courts assign a professional that is cleared. Finally, a strategy should be developed to facilitate access to evidence-informed programs and services and to explore the experience of jurors after they completed their work. Look, admittedly, these measures will not put a stop to the challenges jury members may experience after participating in a trial involving extreme violence. However, we believe that publicly acknowledging these issues, as the committee is doing, and hearing from witnesses from a wide range of experiences and expertise will go a long way to identifying long-term solutions. Thank you for the invitation to participate in this hearing. Merci énormément.
Merci beaucoup pour votre témoignage. Je suis certain que M. Rankin va prendre votre carte pour la présentation au caucus de l'NPD. Maintenant, on va passer aux périodes des questions. We're going to move to the question period. People who have not been familiar with this process in Canada, what's going to happen is the official opposition will have the first round of questions, then the government, then the second opposition party, then the government. And then what we do at this committee is then we just go to everybody who wants to ask a question, and we don't really go in any rigorous formula because it lets everybody ask questions. So we're going to start with Mr. Nicholson.
Listen, thank you very much, and thank you very much for all your testimony here today. I really believe that this is making a difference and will make a difference. So thank you for all the efforts that you put into this. Ms. Goodman de la Hunte, if I could ask you one of the questions, you said it sounds like you're experiencing some of the same challenges that we have with respect to our Section 649. You said no discussions are allowed. Is there any suggestion among the within the governments or the administrations that maybe some changes should be made to allow jurors, for instance, to talk to their psychologists, their psychiatrists, that sort of thing? Is there going to be any changes in that?
I mean, before the trial is over or post-trial,
well,
I think there is a difference. In other words, if somebody post-trial consults the services that are available with mental health professionals for counseling, that information I think would be regarded as confidential. And they can talk. I think the distinction that has been made is between talking about their experience, if it were stressful, for example, during deliberation, versus the issues that are off limits, which are, the processes and content of the reasoning for the decisions for the verdict.
Some accommodation available after the trial, is there, for them to discuss these confidential issues? You didn't mention, among other issues, the question of compensation. What, if any, is the compensation down there, or does it vary from state to state in Australia? It
varies considerably from state to state, and I think that along Along the lines of what one of the former speakers said, we have recommended that the compensation be increased where it was clearly out of date, or people had to rely on employers as well. For example, in Sydney, one of the difficulties is that many jurors, if they turn up and are not required to stay beyond 1 p.m., get zero compensation. This was seen as a disincentive as well. And so in line with some of the thinking that we've heard from other speakers today, we've recommended that a respectful sign of jurors would be to compensate them adequately for their time so that they're not facing excusal by losing money or bearing a financial burden on top of other burdens associated with jury duty.
Thank you for that. And you, Ms. McDonnell, raised this issue as well. Wouldn't you agree that not only do jurors experience the stress of what they're hearing and the actual court case, but adding to their stress can be the fact that outside of the jury, their home situation is being challenged because they don't have they're not getting the resources that they need, or the home care, or the elder care, child care, all that sort of thing. That it seems to me would be a huge stress.
Well, I think it's absolutely true that it's a stress if the potential juror even gets that far, right? So one of the concerns is that individuals will seek sort of preemptively to be excused. Potential jurors who've received a summons will seek to be excused on the basis that they have childcare responsibilities or the like. So a lot of the time, either these individuals are excused before they ever show up to court, or they show up to court and provide their explanation, and they're excused. And so that obviously is a huge problem. And then, of course, for those jurors who do end up sitting, of course, this inadequate income supplement is a big problem. There was some mention of travel. This is another significant factor, particularly in Ontario, for example, I believe it's in North Bay. This is one of the biggest judicial districts in the province. There's one center that holds jury trials. And so you're in, now, excuse me if I've confused North Bay and Thunder Bay. I'm not from Ontario, but it's a huge problem. It means that people are often required to travel quite some distance to not only have their trial heard if they're an accused person, but also to serve on a jury. So this has been part of the reason, it's one reason among many, why there's been a real issue with Indigenous people not ending up on juries. So we need to think about what's the cost of requiring people to travel if they need to travel. What's the cost of meals, for example? Once a jury is if a jury is sequestered, then there are potential costs associated there too. So there's a need to think about this closely. And if you don't mind, I may also just pick up on your point about Section 649 of the code, and this is the juror secrecy rule. Now, just putting my constitutional lawyer hat on here for a moment, or constitutional law professor hat on, there's some question about how much of this the federal government can act on and how much will require some collaboration with the provinces. But certainly one thing that the feds could do that would help support this initiative would be to propose some amendments to Section 649. So this, in my view, this could be done fairly narrowly. Depends how broad you want to go, of course, but you could just amend the juror secrecy provisions of the code to allow individuals to access a counselor who, of course, we already know that these counseling services are confidential. So many of the concerns that animate the juror secrecy rule, the desire for decisions to be final, the desire to preserve the integrity of the deliberation process, preventing jurors from being sort of subsequently harassed. None of those concerns are really at play if you created a narrow exception that allowed people to
give us a possible draft for changes to 649. I know that
it would only be a sentence or two.
Good.
It's really not complicated.
Good. And if you want to give any thoughts to that, we would be very interested in seeing that. I know I'm running out of time, Mr. Chairman, Mr. Rodriguez. Thank you so much for your comments here and your 5 points here that we will have to look at and explore. Ms. Davies, you mentioned, I was intrigued by one report that you said, I think out of the, was it maybe the University of Toronto, but the mental health of lawyers. What was the name of that again? And I'd like to get a copy of that, Mr.
Sure,
Chairman.
I can find, it's a professor by the name of Ranit Dinavitzer. She does a lot of research both in the US and some in Canada around the mental health of lawyers, and I can certainly find a link to that report and get it to you.
I would very much appreciate that because I think that'd be very insightful.
American study of about 12,000 lawyers, but it's a very extensive study. But I can get that to you through the chair of the committee.
Thank you. Well, we'll circulate it.
Mr. Chairman, but thank you.
No worries. Well, we'll circulate it as soon as we get it. So next we'll move to Mr. McKinnon.
Thank you, Chair. I'd like to start with Dr. Kamkar, please. I'm interested in. There's so much testimony we've heard today and through many other days of our study that the stresses arise throughout the whole process of the trial. One of the big things that seems to be needed is the ability to have counseling during the trial as well as afterwards. So my question to you, Dr. Kamkar, is given the state of affairs now where they can't actually talk about the trial, whether during or after, how does that affect counseling?
I think that a lot of times, and thank you very much for that question, is very important. A lot of times it's not always necessarily the content or the details of the trauma. I mean, myself, I'm providing CBT for trauma almost every day. A lot of times it's not necessarily the content, but it's a lot of times, as we talked about, the beliefs around the trauma, and then also the stressors surrounding it. So in that case, yes, we talked about stress around the deliberation, the outcome, the fear of making a mistake. Am I here within the majority vote, about the minority vote? And again, the pressure, the time, and then also whenever the trial ends, what they hear on the media, the family's opinion, the friend's opinion, people start talking about it, people's perception of them. So a lot of times, a lot of the stress is really not necessarily always around the actual content, but it's mostly the perception that they might develop about themselves, about others, the concern about others' perception about them. The other thing here also, as you mentioned, I appreciate that, the appreciation around that is really for us to view it on a continuum. So we always look at mental health promotion and prevention and early intervention. So as you said here, during the trial and after, and a lot of times here, things even prior to the trial, to say, you know what, here are some expectations here. Also, because we know expectations prior to attending an event is very much key to our emotional distress. So having any kind of a healthy coping for anxiety, especially anticipatory anxiety, and then also from going from their normal life to the jury duty. So having healthy coping with that, but then also throughout the trial as well. So if they go through any emotional distress, about what could be some key healthy strategies that they can use to better deal with the distress. Again, we can view it on a continuum that it can help prevent going from mild to moderate symptoms or moderate to severe symptoms. Anything, of course, that could help prevent the onset of a psychological disorder. And then, of course, after the trial, for anyone that would need to have access to that, even knowing that there is access also provides a sense of peace of mind as well.
Thank you. So Saskatchewan, for example, is provided for up to 4 sessions and then an additional 4 if recommended by the therapist, I understand. Is that an approach that you see as, I guess I'm concerned by the finiteness, the rigidness, as it seems to me, of that process. Do you think that works for effective counseling?
It's definitely, I'm always, of course, there's always a concern whenever we set any limit. There are significant individual differences. It could be that sometimes, after the trial, we might deal with adjustment-related issues, also sometimes normal reactions, but then also adjustment-related issues that might resolve in about 2-3 months. But then sometimes it could be, the onset of panic attacks. And if I do not know how to deal with my panic attacks, I might start feeling demoralized. I might start avoiding going to places or maybe even returning to my work. And then it could.
So would you say that the prescription for counseling needs to be more open-ended?
Yes, to ensure everyone has the good access and good care. Absolutely. Thank you for that.
Okay, thank you. Would anyone else like to weigh in on these questions? Mr. Rodriguez? Or
can I also, I'm sorry to jump in, Mr. Keenan, but you mentioned Saskatchewan's program and expressed some concerns about the finite limit. Maybe you want to ask Saskatchewan that?
Absolutely, Saskatchewan.
Yes.
Could you tell me the basis upon which you chose four sessions? And it seems to be fairly arbitrary, maybe rigid.
Thanks for the question. We certainly recognize that it's a starting point, and Warren, Mr. Miller mentioned how we based our starting point a lot on the experience of what other jurisdictions were doing. The other dynamic that we considered is that we appreciate that this is an opportunity to provide jurors with support to assist them in getting to a good space after their experience as a juror. But we also very much recognize the need to bridge the support provided through the program to some longer term support that may be necessary for mental health support. So very much a recognition on the need to bridge. This program, of course, isn't in place and can't incorporate those longer term needs for mental health.
Thank you. Would the Mental Health Commission like to comment on this as well?
From the research we've seen that's evidence-based in the programs that we worked on with first responders and within the general workplace, it's certainly very important to make people aware of changes. Oftentimes people may experience things and not know what actually is going on and may not even associate them with mental health issues. If you know in advance and you begin to see changes, as Dr. Kamkar was talking about, in terms of a continuum, you go from that unexpected wake-up call in the morning at 3 o'clock before you deliver an important presentation or paper or something of that nature to all of a sudden not sleeping for weeks. That really begins to create all sorts of changes within the individual. The importance of early intervention, so being able to be aware of changes that you're experiencing that could be related to the work that you're doing as a juror is very important, to then seek help. Otherwise, you may not know for quite some time afterward that you really need help and that you are experiencing mental health problems or the onset of a mental illness. It's a very slippery slope and can occur very quickly.
Thank you.
We're moving on to Mr. Rankin right now because we're out of time on this questioner. Don't worry, I'm sure he'll give you a chance, Ms. Davies.
I got so many questions, such an interesting group of presenters. Thank you very much. I guess just to go on chronologically, Ms. Bihan or Mr. Miller, a question for you, please. You live in a province where there's a very large Indigenous population, and we've already heard Professor McDonnell talk about the Ontario experience where you have very large areas and people will no doubt travel a great distance in order to be on a jury. Have you given any thought to any specific concerns about Aboriginal culture, Indigenous culture, and the need to address perhaps special needs, given their remote location and so forth? They go back to the community. They know one to talk to about their experience when they're cloistered in a hotel room far away. Then they go back and there's nobody there because they're miles from any counseling services. Is that entered into your deliberations?
Yes, absolutely, and certainly over the years as we, continue to review and address concerns that may arise periodically on the overall jury management system. A key group in Saskatchewan that we seek the advice and counsel from is an elders forum. There are a number of occasions over the years where we've sought their advice and made changes in regards to that advice, and that's certainly something that we're committed to continuing to do in the go forward.
That's great. Thank you. And Ms. Davies, I know you wanted to jump in. I'm going to jump right in and ask you a question.
Okay.
And I guess there's two questions for you that I think are different. But the first is you tantalizingly told us that you had a case where jurors' supports were provided, and yet you didn't, I don't think, tell us about any experience, positive or negative, that you might educate us upon. Sure. But my real question was when you talked about the needs for others in the courtroom to have counseling services where required. I was fascinated by that. I was thinking, though, that in the defense bar, and I really appreciate the 1 in 4 lawyers with mental health issues, and especially women and racialized minorities, and finding themselves in the defense bar without the benefits of the state system that might be available to a Crown Counsel. I very much respect that. In my province of British Columbia, there's a very effective program the Law Society offers for free as a member of the Law Society that deals with mental health issues, drug addiction, alcohol, etc. And so I wondered whether that wouldn't be a sufficient place to go and just perhaps maybe make it more robust in funding. And lastly, if you're a defense lawyer, some of what you might be particularly traumatized by, ironically, could be things you can't talk about because it's subject to a solicitor-client, where you've got evidence from from your client that is really traumatic. You can't share it with anybody because you're their lawyer. So how do you? I'd like to, if you could address some of those ideas.
So the first question was, what case was I involved in? It was the coroner's inquest into the death of Ashley Smith, in which there was videotaped evidence of her in custody. She was the 19-year-old who died in Grand Valley Institution, and there was a lot of videotape evidence of her acting like a normal 17-year-old, joking around. There was video evidence of her being forcibly injected with medication, and ultimately there was a video of her dying because they had been ordered to videotape her. So, and lots of very difficult evidence. And throughout that process, which was different because it was a coroner's inquest, so there was nobody's liberty interest at stake, so there is a bit more flexibility around how you can deal with jurors in those cases. On an ad hoc basis, the coroner, Dr. Carlisle, who was the adjudicator in that case, he provided support throughout the process to the jurors and afterwards. I don't know how. We know that the jurors took him up on that offer. We knew very little about it for obvious confidentiality reasons, but we also know that it continued after the case was over. So that's the only case I've been involved in. There are unique challenges to trying to do it during the hearing, particularly in a criminal trial, because you don't want someone external to the jury interfering with their deliberative process. I think that's a real challenge in terms of providing support during a criminal trial, because you do want them to be the decision makers and receiving the instructions from the judge. But that was the case that I was involved in. And I don't know how successful they would say it was, but it was certainly reassuring to all of us involved. And certainly during that case, I, out of pocket, had mental health supports that I relied on during that process to deal with, in a preemptive way, any issues.
Was there no Law Society help for you?
I might have been able to go through the Law Society. The Law Society program in Ontario is quite restricted. I did it privately because of, there's also, juggling schedules, and a lot of what the Law Society provides, at least in Ontario, as I understand it, although I would invite you to get other information from the source, is a lot of sort of over-the-phone counseling and counseling by email. And so for me, that wasn't the sort of thing that I would have benefited from. So I think there are real restrictions in terms of what is available through the member assistance programs, and they're not consistent across the provinces. Some are better than others. And so I think what my recommendation would be to extend these benefits to people who don't otherwise have access to them. So it may be that restriction would be limited if there is a robust support system from the law societies in a province, or it would be available in other provinces where they aren't. The last question was about privilege. That's something we have to navigate, absolutely, and we would have to respect privilege in any discussions that we have with anybody. But as Dr. Kamkar said, you can talk about the issues without disclosing privileged information. Often, the information that is traumatizing becomes part of the public record. And so once it becomes part of the public record,
I'm talking about when it doesn't.
Right. So you would, in fact, defense counsel would be restrained in what they could disclose to a counselor, and they'd have to be governed by their obligations in terms of privilege, and that would limit the ability. But having access to supports that. The other thing I think that's important is having access to supports that are in person if that's what they need. I mean, it's really important to connect people with resources that will work for them, as opposed to here's a phone number that you can call.
Am I out of time?
You are, but if you do you have a really
I just
quick
got
question?
one, if I may. Yes, it's okay.
Really quick, yeah.
Yeah, well, I was really appreciative, Mr. Rodriguez, about how you helpfully summarized the 5 recommendations that CMHC made. And number 2 and 4 were kind of linked. One was, if it's a dramatic case, that you should arrange, you say, for mental health professionals during the trial. And then, of course, you said, understandably, Section 649 of the Criminal Code may need to be addressed so people can access professional help. They're kind of very much linked, right? You can't do one without the other. So do you have any thoughts about that and how it might work?
Well, there are other experts around the table who may have more specific ideas. Around the actual services, the important part is for the individuals to have access to prevent. So they need, you're going to be listening in on very traumatic experiences, and those are going to be related during court. You should have access to pre-trial training so that you get to build resiliency. Then throughout the case, you should have access to counseling. Now, one of the areas where we are trying to expand, because we know we have there are challenges in terms of access to mental health services across Canada, we are trying to be very creative. So we are trialing a program now in Newfoundland and Labrador using e-mental health therapies. In Great Britain, those have been demonstrated to be as effective for mild to moderate depression as face-to-face counseling. So there's also an encouraging element, which is we could be very creative in how we're able to offer these services to jurors. So I'll leave my comments at that and perhaps open it up to others if you want to address specifically.
We've got to move on to Ms. Khalid. Ms. Khalid.
Thank you, Chair, and thank you to all of the witnesses for coming in today and for all of your compelling testimony. If I may start with Professor Goodman-De Laurentiis, you spoke about perhaps debriefing by judges to jurors to give them that closure. And we did hear testimony previously about that need for closure that a lot of jurors expressed was so important to them. And we also learned that some provinces do it, some judges do it, but it's not something that's across the board. So what is your opinion? Do we need to provide training for judges? And if a national kind of action plan was to be created for providing that support to judges, how important is that training piece for judges? And then building on what Ms. Davies and Ms. McDonald said, moving it to all administrators of the justice system, perhaps. If I can have your comments on that, and then I will ask both of you to comment on that as well. Thank you.
Okay, certainly. I think that there are some judges who are going to be more comfortable with that kind of role and others who are not. And it seems to me, in looking at the literature on this topic, that there really are two different models. Some where judges have turned over they've been present but have turned over more the facilitation of the debriefing to someone with facilitation and mental health counseling expertise successfully, and the judge is available to fill in on some of the legal aspects, and other judges who are comfortable to do that on their own. But who may nonetheless benefit from some training. So I don't know that imperative that a single type of model be adopted, because I think there will be individual differences with the judges as well. But I think what's important is to provide that opportunity, and some judges simply undertake to have their offices follow up with the jurors and let them know, for example, when a sentencing proceeding may eventuate. That is something of much interest to many of the jurors, particularly if they've, participated in the decision on guilt, to know what the follow-up will be, so that they're not simply left with a sense of being participants and then abandoned as the case goes forward. Sometimes jurors do want to attend those follow-up proceedings as well. So that sort of facilitation, many judges feel more comfortable with.
Okay.
I can tell you what my experience is, which is that it is completely inconsistent. I know some judges do debrief with the jury and give the follow-up information. So some trials I've been involved in, a number of the jurors showed up for the sentencing hearing. Some, none did, and I doubt that there was any debriefing at the end. So I think it would be. You've heard the evidence from jurors about what would be helpful or not helpful, but I think to the extent that that is going to become part of the process, I think training judges around how to do that and providing them support if they're one of the ones that doesn't feel comfortable doing it would be important. Although if someone else is going to do it, if you're going to have a facilitator, you still run into the Section 649 problem, because you're then there may well be discussion in that debriefing that would run afoul of Section 649. And the one thing that does happen in every jury trial I've ever done is at the beginning of the trial, the very first thing they're told is it's a criminal offense for you to disclose the contents of your deliberation. And usually the very last thing they're told before they leave the courtroom is, thank you for your service. It's a criminal offense for you to discuss the contents of your deliberation. So that is absolutely the clear message. And so if you want them, I think you need to do something to help jurors navigate what that means. I think if I was a juror completely untrained, I would think, I can't talk about any of this with anybody ever in any context. And trying to navigate, some psychiatric symptom as a result of the trial process or this or that and figure out what's captured or not, I think the message would be it's all covered. And I don't think they would be wrong in that interpretation. So my experience is inconsistent. I think if you're going to recommend that this be a consistent practice, that there needs to be appropriate training.
Thank you. Just following up on Section 649 as well. I know we've heard that the ability to be able to seek counseling not just after but during as well. In your opinion, then, do you think there could be, some coloring of opinion of a juror who could go through the potential process? And so, in that case, are we having an additional juror just by virtue of a juror seeking counseling during that time of a trial?
I think that would be the concern, that you need to preserve the integrity of the decision makers. And when there's 12 of them, you need to make sure that the decision is the decision of those 12. And there's criminal offenses of tampering with juries and interfering with juries. Not suggesting counselors will do that, but given that we have it as a criminal offense, we're obviously concerned with intentional, but I think we also have to be worried about unintentional interference with the deliberation process. So I think it's a much more complicated question in terms of the fairness of the trial, fairness to the accused, to provide supports on an individual basis. That's not to say you can't provide education around these may be some of the symptoms, these may be some of the issues. Like, that's one thing that you can provide education. Providing individual counseling to jurors through the process that permits them to talk about deliberations, I think runs a real risk of creating unfairness in the jury process that you won't be able to ever measure. You would never be able to measure whether it's unfairness to the Crown or unfairness to the accused, because it would be in a confidential environment.
I guess my last question to both of you as well. Something that came up a lot when we heard from jurors was that the same testimony or evidence or viewing of evidence in a trial affected jurors differently, and the impact that they have, whether they need the counseling or not, really depends on the individual person and how they internalize what they see. I guess, is there room then when it comes to the actual selection of the jury process to set in some measures to really allow people to kind of opt out if mental health is a concern to them, or is the onus, or can the onus fall on the lawyers that are going through the jury selection process and the judge to ask those pointed questions when they're selecting the jury?
It's a very interesting and complicated question. With few exceptions, we have really resisted any kind of jury vetting on the front end. And so in the US, there is a very extensive voir dire system where potential jurors are asked a number of questions about by the lawyers about features that might have a bearing on their jury service. We have not gone that route on The View for all sorts of reasons, for reasons of juror privacy, but also out of, I guess, a sense that we have to sort of assume that jurors are in a position to serve, and if we start asking too many questions, that's problematic. And I mean, on the one hand, it might make sense to say, well, maybe we should consider asking jurors if they think they might be impacted. That type of inquiry, the rationale might come from a very good place, but then, of course, the flip side of that is the significant risk of stigma, right? The significant risk that all of a sudden we're looking for a particularly mentally fit type of juror, right? And that kind of inquiry is a lot darker, right? And so there, occasionally there are questions about, should we question jurors about their competence? When there have been some very high profile cases in the past where, in the UK, for example, where it's come out after a trial that there was obviously not a basic understanding on the part of jurors of the legal concepts, and that had those things can have a potentially devastating impact, right? But again, the idea of asking jurors, measuring their competence in advance, that can go south very quickly, right? So this kind of questioning, it raises a lot of difficult questions. I'm a skeptic.
Thank you.
About not sort of going there as a positive step, but jurors are invited to articulate any undue hardship, and so it may be if you are, I think the only thing you could do in this respect is encourage the questionnaire that gets sent out in advance to include that as a potential ground of hardship that the court would be willing to consider if the juror wants to volunteer the information. But I think you have to respect the autonomy of jurors and not create another exit because we have such a problem with underrepresentativeness on juries.
Thanks so much. So now we're going to go to what we call our short snap around, where the question has to be relatively short and pointed, and the answer also, I'd ask you to be brief in the answer so we can get as many as possible from members. Mr. Cooper, Mr. Mendicino, Mr. Fraser had put up their hands so far, and if anybody else, Mr. Rankin and I have a short one too. So, Mr. Cooper?
Well, thank you, Mr. Chair. I have two questions, so I'll pose them both, and then the witnesses can answer. Mr. Rodrigue, you made reference to the need for pre-trial training in certain difficult cases where the evidence might be quite gruesome or difficult to deal with. I think you alluded to 2 programs or training programs in your testimony. I don't know anything about those programs, so perhaps you could just expand on what the scope of that pre-trial training would look like. And Professor Goodman-Delahunty, I was wondering if you could maybe just talk a little bit about some of the programs, if any, that are in place in the various states of Australia to the degree that you're able to comment on that.
Thank you, Mr. Cooper, for that question. I'll pass it off to my colleague who is primarily responsible for those programs, and he'll be happy to outline briefly what those are.
Basically, these are preventative programs designed to make people more aware of their own mental health and mental wellness and look for signs and indicators. We don't want people diagnosing themselves, but you can tell a lot about changes in mood, sleep, addiction issues, all of those kind of things. So the more aware you are of these, the easier it is to get help. At the same time, we provide coping strategies to help you move along that continuum to a much more positive and mentally well state. So that's what we're looking to do, is to, if you have that kind of situation where people are going to be exposed to trauma, again, it triggers some people and others are able to deal with it. But if you're aware, you can seek that early help and support to make sure that it doesn't become a much more chronic issue.
Thank you. And with respect to the programs in Australia, I'm not aware of any that are pre-trial preventive kinds of training, such as we've just heard about. The services that are available through the jury administrators' offices are more akin to what Saskatchewan appears to have, where there are professional counselors who can be accessed by individual jurors in situations where they feel stressed. Generally, we've learned that the mere existence of them needs much more publicity to jurors so that the uptake occurs. There have been barriers to their use simply because although they were there, they weren't, very evident to jurors who came on board. And so a great deal needs to be done to make those more visible.
Thank you very much, Mr. Mendicino.
Thank you, Mr. Chair. And I want to pick up on a point raised by Professor McDonnell around the sharing of jurisdiction when it comes to many of the ideas which we've been discussing today around mental health. And so we take some guidance from the criminal code in as much as where the federal government is directly involved in setting some parameters. And when you look at the code, you see a lot of guidance with regards to the procedure of impaneling and discharging a jury. But there are also some substantive protections around the secrecy of juror deliberations. A lot of what we've been talking about today around mental health and allowances and hardships and some of the recommendations which have been put forward actually find themselves in provincial statutes and regulations. So my question to you, and you can answer and then perhaps others can weigh in, is for the purposes of this committee's deliberations, as we get our heads wrapped around this collectively, where is the appropriate entry point for the federal government in navigating around the shared jurisdiction of this important issue? Thank you.
Right. So I haven't done a sort of detailed federalism analysis of this issue. And I know Brice has some things to say, though, about the potential kind of spending aspect of things. So I'll leave her a moment. But the way it tends to be framed is we tend to talk about everything up until the point of impanelment tends to be dealt with by the Provincial Juries Act. And then kind of from there, well, I guess even part of the process of impaneling the juries, that's sort of where the federal jurisdiction kicks in, right, with the criminal code provisions on peremptory challenges for cause. So a lot of what we're talking about strikes me as being a provincial matter, the kind of thing that, like you said, you'd find in the Juries Act. But certainly on this question of juror secrecy, I think that's absolutely a matter for the federal government. Look, I mean, you have Ontario, Saskatchewan recently rolled out these programs. These programs are being implemented provincially. So my sense is that you're talking about collaboration when it comes to a lot of these things, with the feds and the province playing an important role. And maybe, Brice, you want to just say something about the spending dimension?
Yeah. So, I mean, obviously, this is a point of intersection between federal and provincial jurisdiction where you're talking about the administration of justice. And a lot of what we've talked about has to do with the administration of justice, which is a provincial power. But obviously, you also have cost-sharing agreements between the federal government and the provinces, and those have changed over time. And we've seen, historic reduction in the federal contribution to things like legal aid and all of that sort of thing. So my caution is that to the extent that you are going to encourage provinces to do this, which may be all you decide you can do on a particular issue, that you want to collaborate with them and encourage them to do this as part of their jurisdiction. I caution that if you encourage them to do it in a particular way within a finite package of financial resources, they will do this at the expense of another part of the system. And almost inevitably, that will be at the expense of legal aid funding, because that almost inevitably funding to legal aid and defense counsel is the easiest thing to cut, because nobody's going to be up in arms about that. Funding to other things often gets priority. So I would encourage you that if you want this to be something that happens across the country, that you also think about sharing in the funding of it.
Mr. Rankin, and then Mr. Fraser.
Thank you, Chair. This is a question for Professor Goodman-Delahunty. It's a short snapper, as the Chair said. You mentioned that New Zealand was a leader in this field, and I don't know what you were referring to. You talked, when you said that, about the greater awareness of the conditions in the jury room and so forth. But do they have a counseling support program or the like that led you to conclude they were a leader? What did they do to make you say that?
I was referring specifically to their use of deliberation aids in the form of fact-based question trails or decision trees for jurors to use to facilitate the decision-making process.
And lastly,
and not to any other aspect of juror support or counselling.
And lastly, you said that 20% of Australian jurors take you up on these counseling or these programs that are available. And you said a general debriefing is positive. What does that include, a general debriefing? Is that just a conversation with the counselor if you'd like it at the end? Or what is that?
Those are two different things. So the counseling service, and those statistics are some years out of date. So they're the most recent we had. But the debriefing is a different process. That is simply a discussion in open court, usually, between the judge and or someone else. And mostly in the Australian context, it has been judges who have implemented that system on their own volition to provide jurors with closure. So that would not necessarily involve a counselor.
Thank you.
Thank you very much, Mr. Fraser.
Thank you very much, Mr. Chair. Thanks, everybody, for joining us today. It's been very interesting. I have a practical question, if I can, for the folks from Saskatchewan. We heard previous testimony earlier on in our study about some challenges that jurors were facing at the courthouse itself. And Professor Goodman-Delahunty touched on some of the things that can be done to make it more comfortable for jurors, even something as simple as having a window that opens or more collaborative sort of atmosphere for jurors. We heard earlier in testimony that there was issues with regard to even the parking, that they would be parking, sometimes jurors arriving at the courthouse at the same time as perhaps the victims' families or others that were in the courtroom. And I wonder, from the Saskatchewan experience, whether any thought has been given to that, and whether juries are, whether the aim is to make jurors as comfortable as possible.
Yeah. Thank you for that question. I'm happy to elaborate a little bit on other things going on in Saskatchewan. The rollout or the launch, if you will, of the Juror Assistance and Support Program is really one initiative that's part of an overall review of our jury management system. That overall review certainly includes taking a further look or deeper dive into some emotional supports along with those financial supports. Certainly goes towards education, certainly goes towards taking a look at the information we have available in our summons packages, but it also takes a look at, can certainly take a look at some of those comforts in regards to facilities. Specifically in regards to parking, we are able to provide parking when jurors have been selected and are participating on a jury itself. So that's something that's allowed for as part of the reimbursement expenses that exists in our regulations.
And do they have their own entrance into the courthouse, or are they interacting with people that may be nervous being next to?
Yeah, you know, I would say that it varies. Saskatchewan has the good fortune to have many beautiful and traditional historic courthouses in our 9 judicial centers, and that's something to be very proud of. And you can appreciate that sometimes what comes with that, particularly as the number of matters that are proceeding perhaps at the same time, some of the complexities of the case. We are finding ourselves where those difficulties can be experienced. I'll ask Warren, Mr. Miller, to address it just with his particular experience as a sheriff and what he's experienced in those situations.
So specifically, if you're speaking of the Victoria Avenue Courthouse in Regina, there are only 3 areas of entrance or exit of that building. So we have to coordinate the egress of accused persons, jurors, witnesses, families, and the public through those 3 entrances, obviously trying to limit contact wherever possible.
Thanks.
So the facilities themselves present challenges, but we do our best to manage those.
I have a brief question. Mr. Van Kesteren has a question. So my question is to Professor Goodman-Delahunty. It's a comparative law kind of question based on your experience in Australia. As you know, you've been hearing us talk and opining about Section 649 in the Canadian Criminal Code that restricts jurors from talking about deliberations of the jury post-trial. And I know that you have your experience from Washington that you had talked about, where in the United States they don't have such a restriction. I was wondering if you could tell us in Australia, is it federal or state that would govern that, and would there be a distinction between New South Wales and Victoria, et cetera? And would there be any restriction or not? And based on your accent, I'm guessing you're from South Africa, probably Johannesburg. So I'm asking also, do you know what it is in South Africa as well?
Okay, I'll start with the last part. As far as I know, they have no jury trials any longer in South Africa.
Okay.
So that's out of consideration. In Australia, by state, there are similar provisions that prohibit the discussion of the contents of deliberation, but it is state law that would govern those. There is a provision for jury trials on some Commonwealth matters, but those are very rare, and then would have their own separate law about that issue. I think despite the state differences, they're very parallel.
Thank you very much. Mr. Van Kesteren.
Well, thank you, Chair. And I was going to go on along those same lines. I'm the only one on this side that's not a lawyer. I'm a businessman. So when I look at this, I think, Jesus. So one of the questions I wanted to ask, I think I want to ask this to our law professors, is there a trend? I'm curious, over the last 50 years. I understand that most trials, maybe I'm being presumptuous when I say that, are plea bargain at this point. More and more, there's less and less trial. So has anybody done a study to see what the trend is? Are we how many trials are we talking about? And then the second thing is what Mr. Housefather was alluding to. I don't know if he's alluding to that, but of course our law is part of the British system. We have a tradition that has the trial by jurors. But is there any talk within the law profession about moving away from that and moving towards what other jurisdictions have done for centuries, and that's just trial by judge, or increasingly start to do that?
That would require you to amend the charter. So that may be bigger than what you thought you were biting off with this question. I think one way to deal with that issue about, in some cases there's a requirement for juries, right? Unless the Crown consents to it not being a jury. And so one way there are many people elect to have a trial by judge alone. Many people would elect to have a trial by judge alone, even in those cases where it's required. So if you're looking to limit the number of jury trials, one thing you could do is to allow an election to be done in every case, regardless of what the offense is. We've got 469 of the Criminal Code, which requires there to be a jury unless the Crown consents otherwise. And so you could just do away with that and have an election in every case if you wanted to limit the number of jury trials. I think I don't know if there's research on trends in the number of jury trials or not. I think it depends on, it varies from jurisdiction to jurisdiction, I think.
I don't think I have anything to add.
And had raised his hand saying one last question, very short, Mr. McKinnon, and then we're going to break. Mr. McKinnon.
So, Ms. Davies, you expressed concern about the idea of individualized counseling during the course of a trial. I was wondering if that could be addressed by having a suitably appointed, suitably certified, court-appointed counselor. And at the same time, I'd like to ask the opposite question of Dr. Kamkar, whether group counseling during the course of the trial would be effective. So maybe we start with Ms. Davies or Dr.
Why
Kamkar.
why don't you start?
Thank you. Because I was actually, even when we had finished that conversation, I was actually thinking about it, and I wanted to include something. So thank you for that. People can still benefit without necessarily talking about the content of the trials and the materials, which I understand, the legal restrictions. People can really learn evidence-based cognitive behavioral therapy skills and strategies to manage anxiety, mood changes, or any emotional distress. So it will be a wonderful, again, preventative strategy. So again, we do benefit from evidence-based CBT strategies, just generally speaking, how to manage my emotions, how can I manage my sleep, how can I manage any negative thoughts or worries that I might be going through, without, again, talking about the content. So those general strategies, in addition to, as you mentioned before, education, can be tremendously beneficial as well.
That could be done very effectively in a group context?
Yes, it can be done in a group as well. So in terms of, Ms. Davies mentioned education, of course, and then also in terms of, evidence-based CBT strategies and skills for better management of, variety of skills and strategies. Again, we can learn to better manage our emotional distress or any distressing thoughts we might experience, healthy coping, unhealthy coping, normal reactions, warning signs of stress, etc., etc.
Thank you.
Want to just finish, and then that will be the end of the meeting.
I would just be concerned about the privacy of individual jurors who are experiencing the evidence or the process differently from one another, and the capacity to deal with some of the issues that were raised in terms of interpersonal conflict. If the stress was the product of a conflict, it may be that people wouldn't raise the issues in a group setting. And I'm not a therapist, so I don't know. But those are the sorts of things that would be of concern to me, that we wouldn't want to create a situation that stigmatizes one juror in respect of the group by having them disclose what was going on with them individually.
I guess
She's absolutely right about that. That's very true. This is very true. So, of course, we need to very much appreciate individual differences. I think that if we're going to go with the route of group, having access to individual counseling as well would be tremendously helpful in case of those specific issues that might arise. And often they are more often the case than not.
Thank you. Thank you very much. I want to thank all of the witnesses today. It was a real pleasure to have you testify before our committee. We very much appreciate your testimony and the quality of the testimony. And we invite you, if you have any written submissions that you have not yet provided the committee and you want to provide, to please do so. And have a wonderful day. Meeting adjourned.